gentlemen, this is Olayeni Dieko Daniels, popularly known as Dieko Specter, and today we'll be talking about company law. And the aspect of company law we'll be talking about today would be the Memorandum of Association and the Articles of Association. So do note, most of you will be wondering why exactly I'm not seated. One of the reasons why I'm not seated is because I want to show you that I'm tall, obviously, and secondly, because it's going to be quite difficult to talk about the memo while being seated, because there are so many things in the memo which has to be illustrated. Don't worry, by the time we go through the topic and everything for today, you would understand why. So one thing I want you to do for me right now is to get a biro, get a piece of paper, or possibly a book, get the CAMA, which is the principal legislation governing company law in Nigeria, and then lastly, please get a bottle of Coke. What were you expecting I was going to say? So now, moving into the topic, that is the Memo and Articles of Association. I want us to look at, permit me to use this, don't worry, I'm not going to beat anybody. I want us to look at the meaning of the Memorandum of Association as well as the Article of Association. The Memorandum of Association and Article of Association in under jurisdictions, I coined both of them to be MEMAT, Memo and Articles. The third one is which is more powerful, the memo or the article. While the last one we'll be looking at is the effect of the registration or non-registration of the memo and articles. So let us start with the first one. What do we mean when we say Memorandum of Association and Articles of Association? Do note that a company is governed by three legislations or three things, which is number one, the provisions of the CAMA. The provisions of the CAMA, especially the mandatory provisions, are binding on the company, which is the reason you don't need to include mandatory provisions of the CAMA inside the memo or the article. It's not necessary, it's already mandatory, you don't need to include it there. Then number two is the Memorandum of Association and the Article of Association. The both of them serve as the constitution of each company. And then if we look at section 35, please, we can grab our CAMA now. If we look at section 35 sub 2b, it says there shall be delivered to the commission the Memorandum of Association and Articles of Association complying with the provisions of these parts of this act. So which means by section 35 of the CAMA, it is mandatory. Section 35 of CAMA, it is mandatory that every association have both the Memorandum of Association and the Article of Association. It is very compulsory as it is a mandatory provision. So now that we know that every association must have the both of them, the next thing we have to look at is what exactly would both of them mean. Now we're going to start with the Article of Association. When we talk about the Article of Association, what exactly are we talking about? So when we are talking about the Article of Association, we are saying how exactly is the company governed. So here we have a company. Now, every rule that governs the internalities of a company is usually written in the Article of Association. So the Article of Association governs the internalities of the company. So I will give an example by reading out some provisions. Section 135 says, subject to the provision of section 136 and 137 of this act, the shares of a company and any premium on them shall be paid up in cash or where the articles permit. That should be underlined because this is a default provision. Where the articles permit by a valuable consideration other than cash or partly in cash and partly by a valuable consideration other than cash. So according to the provisions of the CAMA, that particular default provisions, the premium or shares of a company is to be paid in cash. But if your article, which governs the internalities of a company, says otherwise, says that it can be paid partly in cash and partly in valuable consideration, then the article of the premium or shares can be paid in any of both ways. But this is just to illustrate that the articles govern the internalities of a company. Now, if we look at section 63, subsection 3, it says that except as otherwise provided in the company's article, the business of the company shall be managed by the board of directors, who may exercise all powers of the company as are not by this act or the articles required to be exercised by the members in general meeting. So now the only time you can restrict the powers of the directors, which is something that is an internal issue, is when you do so by the said articles. So now we have both section 135 and section 63 sub 3. Now, there are more and a lot of other default provisions in the CAMA, but I'm just using these two sections to illustrate to us that the articles govern the internalities, the things that have to do with the company, the internal dimension, in quotes, of the company. The memo governs the external dimension of the company. Let's not forget, the articles govern the internalities of the company, while the memo covers the externalities of the company. So with this, I move straight into explaining how exactly the memo governs the externalities of the company. And let us go to section 27 sub 1. If we go into section 27 sub 1 of CAMA, we would see that it says that the memorandum of every company shall. Now, the internalities is memo, is article, the externalities is memo. And then we have section 27. Just a brief rundown. Section 35 creates mandates a company to have both articles of association and memo. Now we are asking, what exactly is the function of an article of association? And I say it is meant to govern the internalities of a company. I gave example of both section 135 of the Act as well as section 63 sub 3 of the Act. And now I am in memo, and I'm saying that memo governs the external parts of a company, things that has to do with the company and third parties. This one governs things that has to do with the company and the members, shareholders, or the directors, that's the officers of the company. So this one governs the members, shareholders, and the company directors or officers, while this governs the company and third party and people outside the company. I'm trying to break it down so that you can understand how both the article and the memorandum of association works. So when we've got to section 27 sub 1 of CAMA, it says that the company shall, which mandates the company to have written in its memorandum of association the name of the company. It is a must that the company must write its name in the memorandum of association. B, the registered office of the company shall be situated in Nigeria. The registered office of the company shall be situated in Nigeria. Number 3, the nature of the business or businesses which the company is authorized to carry on, or if the company is not formed for the purpose of carrying on a business. There are some companies that are not formed for the purpose of carrying on a business, and that can be seen in part C when it comes to registered trustees, where you are talking about churches, communities, and the rest. A typical example is the registered trustee of the Redeemed Christian Church of God. That is a religious association, and then they are not formed for businesses. If the company is not formed for the purpose of carrying on a business, the nature of the object for which it is established. So this is where section 27C, 27(1)C is where we have the nature of the object. So we are talking about the object clause. The object clause, number one, the section 27 1a talks about the name. Section 27 1b talks about the location. C talks about the object. D now talks about the restriction to the power of a company. So when you have section 27 sub D, we are saying that it says the restriction, if any, on the powers of the company. So section 27 sub D talks about the restriction of power of the company, and then so forth. We have section 77 sub E that says if the company is going to be a private or public company, and then F talks about the liability of members, whether or not it should be by shares or by guarantee or unlimited. Now, the most important part is what we've stated right now. So when you are talking about the memo, like I said earlier, we are talking about how the company, have its relationship with third parties, because the memo is what shows the third parties the name of the company, the object of the company, the powers that have been given to the company. Have those powers been restricted by section 38 sub 1? Now, if you look at section 38 sub 1 of the CAMA. Section 38 sub 1 is a default provision, and that default provision restricts the power of a company, and that should be done in the memorandum. Now, when we look at the section 38 sub 1, it says, except to the extent of the company's memorandum or any enactment otherwise provide, every company shall, for the furtherance of each authorized business or object, have all the powers of a natural person of full capacity. So when you want to restrict the company from having a natural person of full capacity, which you can do by virtue of section 38 sub 1, it must be done in the memorandum by virtue of section 27 sub 1d. These are things that the third party would have to come in contact with, in essence. So now that we have spoken about the memorandum of association and then the articles of association, we've talked about the different parts of CAMA which illustrates them. Now let us look at the memo in other jurisdiction. So basically, we'll be going through to interrogating the memo in other jurisdiction. So when you're talking about the memo, that's the memo and article of association in other jurisdiction, for the purpose of this particular section, we'll be talking about just two, Canada and Australia. Later on, we'll be talking about England, and now England has moved on from the memorandum of association or article of association, as the case may be. So while we are talking about Canada, when we look at section 15 of the Canadian law, we are going to see that the articles of incorporation and the bylaws are what they use now instead of memorandum of association and articles that they used to use before. Almost every company and every country had the memorandum and articles of association, but most of them have moved on beyond it. Also in Australia, according to section 124 and 125 of the Australian company law, you would see that they have replaced their articles with replaceable rules, and they don't even use memo anymore. You see, what countries and companies now do is that they have extricated themselves, according to words of Professor Dieko, they have extricated themselves of the hardship that the memo and article usually confers on companies, because every company will be mandated, just like section 27, to put down its objects and all that. But in other countries, you don't even need to write your objects down in your memo or articles, because according to them, business evolves, so you can decide to change. Just make sure that at every point you always have a lawful business and not an illegal business. So other countries and companies have extricated themselves of the hardship that comes along with the memorandum and articles of association. So now the next thing that we're going to look at is which is more powerful, the memorandum of association or the article of association. So now, guys, we are talking about the memo and articles, and then we are asking ourselves which one of them could be regarded as more powerful. Is it the memo or the articles that, when you are drafting, you should pay more attention to, the memo or the article. So basically, we are going to draw distinction in relation to its power or their power in two distinctions. Basically, we'll be talking about the object and the power clause, as well as the mode of alteration of the both of them. So now let us start with the object and the power clause. You will recall that when I spoke of section 27, I was speaking about memorandum and how it governs the external part of a company. And then I said section 27 sub 1D talks about the power. Talks about the power, yes? Section 27 sub 1D talks about the power, while section 27 sub 1C talks about the object. So we can see that where do we have the most powerful things? The object of the company. Upon what things has this company been established to function? That is the object of the company. So the object of the company is to be written in the memorandum. The powers of a company is to be written also in the memorandum. It shows how more powerful the memo is to the articles, as the articles only would have things that has to do with the governing of a particular company, how a company operates within itself, which I've given sections to that effect. So now we are moving into the mode of alteration, and you see the mode of alteration is very, very dicey, because we have to pay rapt attention at this juncture. Now, so when we are talking about the mode of alteration, I need you to bring your camera closer, because we'll basically be interrogating a lot of sections. I think about 3 or 4 of them, and we'll have to look at what each of those sections say and what each of those sections mean. So the first section that we're going to be looking at will be section 44. So let us look at section 44 subsection 1. Okay, so section 44 sub 1 says, a company may not alter the conditions contained in its memorandum except in the cases and in the manner and to the extent for which express provision is made in this act. Now, there are 2 parts of this particular section that is very, very important. Let us read the first part again, which says, a company shall not alter the conditions contained in its memorandum. Must be conditions in the memorandum. So the company cannot alter the condition included in the memorandum except in the manner stated by the act. Except in the manner stated by the act. These 2 things are very important when we are talking about alteration of articles, and these 2 things are embedded in section 44 sub 1. Let us not forget. Now let us read further to section 44 sub 2. Only those provisions which are required by section 27 of the Act or by other specific provision contained in this Act to be stated in the memorandum of the company shall be deemed to be conditions contained in its memorandum. Now, the first line is very important. Only those provisions. So there are 2 provisions that shall be regarded as conditions here. Don't forget that section 41 sub 1 says that the conditions can only be altered according to the manner stated by the act. So the first thing we want to look at, what are those conditions? The second thing we look at is what is the manner stated by the act by which we can alter a memorandum. Do you understand? So now, the conditions here, there are 2 conditions according to section 41 subsection 2, and the first one is those stated according to section 27. So now we have a kind of diagram here. Those stated in section 27. The 6 things we talk about in section 27 are all conditions. So those are conditions that are not alterable except through the manner stated by the Act. And then when we look at section 44 sub 2, it says, no, the first thing is the section 27 of this Act, or by other specific provision contained in this Act. By other specific provisions. So we have other specific provisions. So now we've looked at section 44.1. Section 41.1 says the conditions in the memo, and the condition in the memo can only be alterable according to the manner stipulated. Now let us not forget that this is section 44 sub 2. Section 44 sub 2. So the conditions and the manner. And now this is talking about the fact that the conditions are divided into two. The first one is section 27. The second one is other specific provision. Now the next question we ask ourselves at this juncture: what is other specific provision? Where can we find these other specific provisions? And this is the point where we move down to section 47 of this Act. Subject to the provisions of section 44, where we are just coming from, and this section, and of any part of this Act which preserves the right of minorities in certain cases, any provision in a company's article which might lawfully have been in articles of association instead of in the memorandum may be altered by special resolution. Now, when you are talking about other provisions here, what other provisions entail has been decided or has been stated by section 47 sub 1. And other provision includes those provisions which should have otherwise been in the article. Those provisions which should otherwise be in the article. So section 47 sub 1 talks about it defines to us what other specific provisions are, and other specific provisions include those provisions which should have otherwise been in the article. So do not forget that we have provisions that are supposed to be in the article of association. So the question is, why do we put the article of association, the provisions in the article of association, inside the memo? Now let us go to the articles of association and let us see how do we alter article of association. Because the question is, why would you want to put provisions in the article of association in the memo? There must be a reason for the creation of this. You know that before you can alter the conditions in a memo, you must follow the manner stipulated by the Act. So how can we alter the provisions of the article? So we go to section 48 subsection 1, which says, subject to the provisions of this Act and to the conditions or other provision, subject to the provisions of the Act, now to the conditions, which is section 27, and other provisions, which are things that should have otherwise been in the article, which is in the memorandum. A company may alter by special resolution. A company may by special resolution alter or add to its articles. Now, the next thing now, how do we alter an article? So now section 48 gives us arrow and says article can be altered by special resolution. Articles can be altered by special resolution, and that can be found in section 48. Now, so we are talking about how to alter. So we are saying that articles can be altered by special resolution, and that can be found in section 48. So the next question we ask, how can we alter memorandum? Now we now go back to that same section 47 that we read, which says any provision in a company's memorandum which might lawfully have been in articles of association instead of in the memorandum may be altered by the company by special resolution. Okay, so now the question is, this one is altered by special resolution. This one is altered by special resolution according to section 47(1). This one is altered by special resolution according to section 48. So why do I want to stress myself by putting provisions which are ordinarily meant to be in the article in the memorandum of association? Why? So that question is answered by section 47(2). Now, when we go to section 47(2), it says that this section shall not apply, which means section 47(1), which talks about other provisions and special resolution, shall not apply where the memorandum itself provides for or prohibits the alteration of any or all of the said provisions, and shall not authorize any variation or abrogation of special right of any class of members. This is wonderful. So now when we go down a little, we go to section 47(2), and it says that this section will not apply. Section will not apply where the company has stated mode of alteration. So now we are saying that section 47(2) will not apply where the company has stated its mode of alteration. Note that the mode of alteration as stipulated by section 47(1) is by special resolution. Now, the company can take something, a provision which should have otherwise been in the article of association, take it and then put it in the memorandum of association. Now, lock it in the memorandum of association by saying that this particular provision cannot be altered except the memorandum of association in itself is altered, or it cannot be altered except particular things are done. Do you understand? So that is not open to article of associations. Articles of associations can always be alterable at any time by special resolution. But the memorandum of association, the conditions stipulated in memorandum of association, and this is where the manner stated by the act comes in. Now, the act has given the company the power to lock a particular provisions and make it more hard, for the company to alter those provisions where, those provisions. And the reason for doing that is because there are some things in a company or some provisions or some, things that the company would want to make more difficult to alter. So when the company doesn't want a particular thing, especially when it has to do with the internalities of the company, those are the things that has to do with the company itself, amongst members or amongst officers. So when we have things that has to do with the company, and when it comes to things amongst members or amongst officers, and the company doesn't want it to be open to anyhow alteration, any special resolution kind of alteration, the company can just pick it up, put it in. So let us say this is a memorandum. So I'm just giving an example now. This is a memorandum in quotes. This is the piece of paper. Now the company has stated all the conditions as in section 27. The company has stated all the conditions in section 27. Now, the company wants its shares according to section 135. The company wants its shares to only be paid in valuable consideration other than cash. Valuable, or its shares to be paid in valuable consideration other than cash. Now, if the company put it in the article, that can be alterable by special resolution at any time. Do you understand that? That can be alterable by special resolution at any time. So the company would now think, okay, we don't want this thing to be altered easily. How do we go about it? Then the company puts it in its memo. Then after it is in the memo, so you have other provisions. So you have other provisions in the memo. So the company puts it in the memo under the other provisions. Then put a clause to it that says that this particular provision shall not be alterable. Do note, if the company had not stated that it shall not be alterable by special resolution, section 47(1) would apply and it will still be able to alter it by special resolution. But because the company has put it in the memo and has stated that it should not be alterable by special resolution, but by this and this and this way, according to how the company wants it to be alterable, then that would be upheld in court. So I hope I've been able to talk about everything that has to do with memo. The first place we started from, we talked about the conditions as well, the section 41, section 44(1) rather, which talks about the condition and then the manner stated by the act. That is the only way you can alter the conditions. So the next question is, what is the condition? We can find that in section 47(2), which says the conditions in section 27 and other specific provisions. Now, other specific provisions were defined in the act under section 47(1) to be those provisions which should have otherwise been in the article. So now we now said, how exactly do we now alter them? By section 47(1), you are supposed to be able to alter it by special resolution, which is the same thing that would have applied to an article under section 48, under section 48, which is still the same special resolution. So now under section 47(2), the section will not apply where the company has already stated rules of altering those sections, which obviously, with everything that has been stated above, shows that the memo is more powerful. And when you want something to not be easily alterable or one or two other things, you can always keep it in the memo. So definitely the memo is not powerful. So at this point, we are going to interrogate the mode of alteration under other jurisdiction. The mode of alteration under other jurisdiction. Looking at the mode of alteration in other jurisdiction, we are going to principally focus on the United Kingdom because we got the laws from England. That England has done away with the complexities that come with memo and articles of association. Even note that more power has even been accorded to the articles of association than the memo in court. Because if we look at section 8 of the 2006 UK Company Law, UK Company Act, you would see that the memo merely states that the subscriber wish to form a company and that they've agreed to be members, and that where the company is to have share capital, they will make at least one share each. That is, they'll take at least one share each. That is all that the memo would prescribe. But what the article says in this circumstance, if you look at section 31 of the UK law, you would see that section 31 talks about objects. It is not compulsory to state your object in your articles of association. But if you want to restrict your object, you can restrict it pursuant to section 31. So it takes away the hardship that the memo has in section 27 that says that your object and your power must be stated. Here, your object and power are not necessarily stated in your memo or articles of association. That is number one. And also note that according to section 22 of this UK laws, there are three provisions that are really important here. Section 8 of the UK laws that talks about the memo, section 31 of the UK law that talks about the fact that you don't need to write your objects in your articles of association. You can only restrict it according to section 31, and also section 22, which talks about the entrenched provisions. Now, the entrenched provisions under the UK law basically is what we have here. So if you don't want a provision to be altered by a normal special resolution, you make sure that that provision is the procedure for alteration would be stated for that particular provisions, just the same way other specific provision and section 27 which will form condition can be altered through a special way according to a company. So the moment you make a special way other than the special resolution, then you have an entrenched provision under section 22 of the UK law. So those are the changes that we can find in the UK law. And then if we move to Australia, we would see that Australia has totally done away with memo, and all they have is replaceable rules. Replaceable rules to govern the internalities of a company, which is just pursuant to our own articles, same as our own article, which is supposed to govern the internalities of a company. So that is what you are going to find in Australia. That's the 2001 law. And then if you come to Canada, Canada has the AOI, which is the Article of Incorporation, and the bylaw. They've done away with memo and articles of association. But according to the law in Nigeria, we have the memo and the articles, which must, because it is mandatory, which every company must have, which is a must have. So what section says that? We have to look at section 35 of the CAMA, and also look at section 33. Section 33 of the CAMA also says that a company must have, along with its memorandum of association, article of association. So at this juncture, we move to the last thing we have today. What exactly is the effect of the registration? When the memo and articles have been registered, what exactly would that mean? What is the effect of it? So when we are talking about the effect of registration, basically we are asking, when the memorandum of association and the article of association has been registered, what next? What does that mean? So we have to look at section 41 of the CAMA. But before we look at section 41, it is very important that we look at section 16 subsection 1 of the 1968 Act. We have to look at section 16 subsection 1 of the 1968 Act, which is the same thing as section 20 subsection 1 of the 1948 Act of England. The 1968 Act is Nigerian, while the 1948 Act is England. They are the same provisions. Now let us read what the provision says. The memo and the article shall, when registered, bind companies and members thereof to serve to same extent as if they would have been signed and sealed by each member, and contain covenant on part of each member to observe all provisions of the MEMAT. Now, one of the problems of this provision is language, because according to the provision, one thing it makes clear is that the MEMAT and articles, when registered, serve as a binding contract between members. But the question is, who else would this particular memo and association, when registered, serve as contract with? Because here it doesn't expressly say that it serves as a contract between the company and the members, or between the officers and the members. It only clearly says between members, and that is one of the things that section 41 of the CAMA, section 41 subsection 1 of the CAMA had corrected. Now it says the memo and articles, when registered, shall have the effect of contract under seal between the company and the members and officers, and between the members and officers themselves, whereby they agree to observe and perform provisions of the MEMAT as altered from time to time, insofar as they relate to the company and officers as such. Now, do not forget that I've spoken about section 16 sub 1 of 1968 Act, which is Nigerian, and then we have the same thing in section 20 sub 1 of the 1948 Act, which is England. So we have spoken about two acts here, and I said the problem here is language. The problem here is language, as the 1968 Act as well as the 1948 Act in England did not say to us, well, what between who and who do we have a contract? That's the question under the 1968 and but according to the 1990 section 41(1) of CAMA, there is a contract between the company and members, between company and members. You have between company and officers, between company and officers. You have members and officers, members and officers. Number 4, we have between members inter se. Inter se means amongst themselves. Members inter se. And also between officers inter se. Officers inter se. So now we have 5 different contracts according to section 41 of the CAMA, which would have been a problem according to section 16.1 of the 1968 Act, and as well as the England Act. Now, to buttress this point further, let us look at section 27 sub 5. Section 27 sub 5 of CAMA, sub 5 and 6. So let us look at section 27 sub 5 and 6 of CAMA. Section 27 sub 5 and 6 says that the memorandum of association shall be signed by each subscriber in the presence of at least one witness who shall attest the signature, and the memorandum shall be stamped as a deed. So 27 sub 5 and 6 read together create a contract under deed. Section 27, and then it talks about memorandum of association. Now, when we look at section 34 sub 3 C and D, section 34 sub 3 C and D of CAMA. Now, it says the article of association shall be signed by every subscriber of the memorandum of association in presence of at least one witness who shall attest, and then the article of association shall bear the stamp duty as it contains a deed. So when I meant section 34 sub 3 and sub 4. So now when we read section 34 sub 3, it talks about the article of association, and then it says it shall also be a deed. So now when we look at the effect of registering the article of association and the members, we are going to see that it has created 5 different kinds of contracts between these people that have been stipulated. And also it has also, these sections also reinforce the fact that these contracts are created under deed, which makes them enforceable. So for instance, let us say a company decides to go or traverse of its powers, or decides to do something that the memorandum of association has told it not to do, or even if it wasn't clearly stated, it told it to do otherwise, but it decided to do something else. Now the members can bring an action against the officers, as we have between members and officers. So the members can bring an action against the officers to correct the officers of what the officers has done based on the contract that they have, according to what we have seen above. So I hope that this video has enlightened you on memorandum of an article of association. I would love you to please subscribe to the channel Olayemi Dieko Daniels. But the channel's name is Dieko Daniels. Make sure you subscribe to the channel, and also like and comment any part you want me to become better, or anything you want me to do, or you think I'm doing wrong. You can always either message me personally, or you can write it in the comment section or something like that. So thank you for watching the video. I am Olayemi Dieko Daniels. I do marathon. She's dancing.